so our legal update today is answering the question, what is a buy-sell agreement and when is it used? So I have a lot of investor clients come to me. Many of them have partners that they want to enter into a business relationship with. They want to form an LLC or multiple LLCs, and they basically want to go into business together and be, say, 50-50 partners. And so, we talk about the different scenarios, what happens if, somebody passes away, or what happens if they don't like each other at some point in time, or someone does something wrong, with respect to the business or otherwise, what does that look like? And how do we basically prepare for those situations? And the answer is a buy-sell agreement. So a buy-sell agreement is basically a prenuptial agreement for business owners. It basically says what will happen in a number of different circumstances. So the first is a dissociation of a member, also known as a withdrawal of a member. The legal term is dissociation, but a withdrawal of a member or an owner. The next is a disability of an owner, the death of an owner, the divorce of an owner, or some type of wrongful conduct by one owner against the other owner or the business. It basically has all of those contingencies set forth in the agreement, specifies what it then looks like if the members or the owners either voluntarily or involuntarily want to go a different direction or no longer can, fully participate or work in the business. So it sets things like, the purchase price, how the business is going to be valued, what things are going to be considered in coming up with that membership interest purchase price. It basically allows for the proper separation of business owners. For about 2 years, and this was a number of years ago now, but for about 2 years before I switched my practice to pretty much fully transactional work, I used to do business divorce litigation, and on a fairly large scale with a, decent sized firm in Phoenix. And we would be representing these business owners, and they would be fighting over these, ownership of these businesses that were worth millions of dollars. And these owners hated each other. That's why we called it business divorce. They were separating, and it wasn't, on good terms. And so they would be fighting, and we'd be fighting over the business. And about 90% of those, I could look at the situation and what caused the fight, what caused them not to like each other, what caused them to want to go their different ways. And then about 90% of those, had there been a buy-sell agreement, we wouldn't be handling the litigation. There would be no litigation because the agreement would control. But the problem is, in those cases, there was no buy-sell agreement. There was no, set formula for the members to separate. And as a result, they were basically stuck fighting with each other and litigating to figure out what it would look like to, lose for one of them to lose control of the company, because one of them had to lose control. They couldn't continue to operate the company because they couldn't get along. They hated each other or disliked each other significantly. And so, and both of them a lot of times felt wronged, but it was a fight versus a buy-sell would provide in what circumstances, who would take control, who would run the company, how the other person would be bought out. And there would be a formula for all of that. So that is a buy-sell agreement. It's basically your prenuptial agreement for business owners. And when is it to be used? It's to be used if you're going to go into business with another person or individual. You probably want to consider putting that in place.